again, we gather in search of the truth, dark, and mystery. It's the Drunk Turkey Show.
Big development today in the investigation into the murders of 4 University of Idaho students. According to state and local officials and court documents, 28-year-old Bryan Christopher Kohberger has been arrested. He was arrested and arraigned this morning in Pennsylvania.
We have new details on what Bryan Kohberger was doing right before his arrest. Police says a tactical team burst in to arrest the Idaho murder suspect. He was in pajamas and latex gloves, stuffing trash into Ziploc bags.
Hey, greetings from the year 3000. It still sucks. This is Phil J. Fry, and you're listening to the Drunken Turkey Show. Your one stop for this sort of thing. Hit that button, like and subscribe. You know what to do, just like every other podcast.
You guys know what to do, just like every other podcast. What is up, everybody? Welcome back to the DT Show. I'm Daniel, and tonight we're going to get back into the Bryan Kohberger podcast, into the Bryan Kohberger case. There is a lawsuit going on right now, pending, with the victim family members against WSU. WSU was the school that Bryan Kohberger attended and also taught as a student teacher in the criminology, I guess, I don't want to say division, but division, a part of the WSU schooling. And so a lot of complaints against them, a lot of questions surrounding do the victims have a case? Do they not? And we're going to bring on an attorney to answer some of those questions tonight. But first, hit the like button, hit the subscribe button, ring that notification bell. I got a lot of things that are going to be planned up this week, guys. In fact, immediately after this show, we're going to go live again and talk about the Nancy Gerthy abduction. There's a ransom note, and that was just left at a couple of different news broadcasts. TMZ, I think, got one, and another news media I think it was local to where she was from, also got some sort of ransom note. We're going to talk about all those things immediately after this show. And then tomorrow I'll be talking about the Spencer Tepe and Monique Tepe case. The autopsies are back, multiple gunshots involved in that case. Questions about, hey, what about the shell casings? There was only 3 found. What does that lead us to believe as far as what this guy was doing immediately after committing the crime? And so you're going to want to catch all of that. So make sure you like, comment, subscribe, ring that notification bell. And without further ado, let's bring on today's guest. We got Matt Rowland, attorney. Welcome to the show, Matt. How you doing?
Thanks. I'm doing well. How are you this evening?
I'm doing well. I'm having it's been a day, and I'm glad that the work day is over and I get to come and hang out with everybody on my True Crime family. For those that don't know who you are and what you practice, could you introduce us to who you are?
Yeah, Matt Rowland. I'm an attorney who practices in several different areas: criminal defense, family law, personal injury, some probate type work, and a few things kind of related to cities and municipalities. But I've been practicing law in 16 years, have been involved in cases at both the state court and the federal court level over that time. So I'm happy to be here with you tonight and talk about this case.
I'm glad to have you. I've been excited to have you on. There's a lot of questions I have, and thank you for that. But there's a lot of questions I have when it comes to this lawsuit that's been brought up. You know, me personally, WSU fired him. You know, it was this odd day. December 19th is the day they decided to fire him, which happens to be the same day that Bryan Kohberger's name is announced to the Moscow Police Department, because the DNA came back from the FBI lab after their genetic tree analysis was done, and it pointed towards Bryan Kohberger. But let's start off there. Bryan Kohberger, he's was a student there at WSU. What is it, or why is it, or what is it exactly that the families are suing WSU for?
Right. So that's a great question. So the lawsuit originated in the Superior Court for Skagit County, which is in the western part of Washington State, roughly.
Okay.
And it was filed in the Superior Court there. Um, my best guess is that it was filed in Skagit County, based on maybe one of the families having ties to that area. We now know that the case is going to be removed to federal court, and it could be removed to the U.S. District Court for the Western District or for the Eastern District. And the reason for that is WSU is, of course, in Whitman County, which is situated within the Eastern District, and so then obviously you have Skagit County situated within the Western District. So I think venue would be proper in either one of those forums. And I may have said that in reverse in the beginning, but I think the notice of removal, for anyone who's read it, references that venue would be proper in either one of those places. So, and I don't know if you want me to kind of go into the reasons it was removed to federal court, or if you want me to.
Well, what is it? What is it exactly that the families are suing for? Is it because they didn't fire him? Is it because they didn't report him fast enough? What is it that the families are suing WSU for?
Okay, so great question. There are basically six principal causes of action in the complaint, and the complaint is 126 pages. It's about 500 numbered paragraphs. I read all 500 of them twice. And so count one is a Title IX violation. Count two is a negligence cause of action. Count three is gross negligence. Count four is a count called outrage. This must be, I'm not licensed in Washington State, but in tort law, which is the area of law that we're in, there are torts known as intentional infliction of emotional distress or negligent infliction of emotional distress. And so maybe in Washington, they just kind of lump that into what they call outrage. Then there's a cause of action for survival and a cause of action for wrongful death. And survival is a cause of action that the personal representative of a decedent's estate can bring. Essentially, it's a personal injury action on behalf of someone who's been the victim of this type of crime. And so those are the six causes of action, and they are all tied, Daniel, to what the university did or did not do in relation to Bryan Kohberger's, really not just his employment as a TA in the criminology PhD program, but really probably also as a student at WSU, and so that's at the crux of all of this. And I think the key question, the Title IX is sort of a little bit of a different animal, but if looking at negligence, gross negligence, the outrage, the survival, and the wrongful death, what we're looking at here is, did the university have a duty to these kids? We see in the complaint a lot of information about how closely connected Moscow and Pullman are. I think those allegations weren't included by accident. I think they were included to show that WSU had a duty to the kids because they lived so close by. And so did the university have a duty to these kids? Did the university breach its duty? was that breach the cause of the damages? Damages is kind of the fourth element that you would need to sustain a negligence claim, and so that's really what we're talking about here. In the survival and the wrongful death causes of action are sort of born out of the negligence, in my opinion. And in the complaint, they separate negligence and gross negligence, and so it's kind of like the degree of, they're alleging that there was an even greater degree of negligence that rose to the level of gross negligence. And so, with any lawsuit, I've seen a lot out there, and I've heard a lot that people saying this lawsuit is just a money grab, or it's evidence of greed. Well, first of all, lawsuits are typically about one of two things: money, or asking the court to order a party to do or not do something. Here we have a combination of the two, I believe. And we're not even we're really just out of the starting gate on this. We have such a long way to go. But one thing that we absolutely should not do is assign motive to the families in the filing of this case. We simply should not do that. I see a lot out there that, this is a frivolous lawsuit. There's no way the university could have known. It wasn't foreseeable. We don't get to make that decision at the end of the day. At the end of the day, it's a U.S. District Court judge, and if the lawsuit survives a motion to dismiss, which I think it will, then a jury. And I think the case was removed to federal court because there's a Title IX claim in there. Title IX is a federal statute that deals with discrimination and assault and and victimization of students at the college and university level. And so because that's a federal statute, it was appropriate for the case to be removed to federal court.
Understood.
I think there's a little bit of a perceived bias too sometimes, that maybe federal court judges are a little more favorable to the defense or to the plaintiffs, but I think it's just a perceived bias. I'm not really sure that it's real. I think this was more of just a question of the federal law being in play. Gotcha.
And so just to kind of unpack a lot of that, basically what they're saying is that the university had complaints and things of that nature and should have been aware and did not act appropriately or in a timely enough manner. And then you also mentioned that it doesn't appear, and I'll ask you this, it doesn't appear that none of the families are accusing, well, maybe they are, I don't know. Are any of the families accusing WSU of maybe supplying Bryan Kohberger with anything, like whether it be knowledge, whether it be access to equipment or anything to help him commit his crime? And then you also mentioned that the close ties between the two, and I want to touch a little bit more on that. But first, I want to talk about what is there anything there about maybe perhaps WSU supplying Bryan Kohberger with any supplies, knowledge, whether it be, information, on how to get dispatch information or anything period like that?
Yeah, he signed an agreement, as a university student, for housing. As we know, he lived at the Steptoe Apartments, which was university housing. There's also, an agreement because students use university technology, right? And of course, he was in a criminology PhD program, and so
right.
He's gonna learn certain things, because of that. Obviously, to what degree he used that is just, kind of pure speculation, probably. but there are some allegations in the complaint related to the the agreements that he had to sign. And I think if I understood the complaint correctly, effectively the argument goes is that they had the obligation to sort of exert some level of control over him by virtue of these agreements, the residential housing agreement, the technology agreement. So I don't think, though, that they're directly arguing necessarily that they supplied him with the kinds of things that he would need to commit crimes like this.
Understood. Yeah, that was one of the questions I think that was, in the minds of a lot of people, including myself. I know that there was some speculation out there that he may have broken into a chem lab or something like that. And I was wondering if he did do something like that and he did utilize equipment that was from WSU, or if he had access to equipment, would we have found out in this? And if the fact that it's not in here, does that kind of dispel that?
I'm really glad you mentioned that because and asked that question, because assuming that the lawsuit survives a motion to dismiss or a motion for summary judgment and it goes into the discovery phase, they're probably the attorneys for the families, and understand that they have a firm in Washington State, but also apparently a firm in Missouri, working on their behalf. Through the discovery process, they may learn things that maybe we didn't even know, through the course of the criminal case at that point, and that could be, that could be one of the things that we learn. Some of these things that we've heard, are we going to learn at some point that they were actually true?
Interesting. If this goes to trial, would Bryan Kohberger testify in this?
Well, that's a great question. I think no, because his period for post-convict, although he waived his appeals as part of his plea agreement, there could be hearings that conceivably happened during his period of time where he could seek post-conviction relief. And I don't know that we necessarily want to go too far down that road, but I've got to think that there's no way, that he testifies.
Yeah, that was one of the things I was wondering. I assume that we're probably going to hear from a lot of the students, maybe perhaps some of the faculty, especially the one who may have mentioned that, what did she say? Something about a predator on her hands, and that he's smart enough to get through this, to graduate. And we're going to find out later on he was a predator of some sort. Those type of statements out there from the faculty really don't help out their case, do they?
No. And, there are factual allegations in the complaint related to how they handled, I believe it was a university police officer. And I think that they included those to just show that perhaps WSU doesn't have the best track record with employees who cause problems, as if to show, okay, this wasn't the first time maybe that they've mishandled an employee. And so I saw that as kind of trying to make a tie, and kind of set up that like, look, because the whole thing with negligence, the toughest part often is foreseeability, right? Does some action that the university took or didn't take, is it then foreseeable that Bryan Kohberger would go out and commit the type of crimes that he committed? And I think a lot of the probably a lot of the motion practice in the briefing that we might see in the case. I wouldn't be surprised personally if it revolves around this idea of foreseeability and causation, where the university might argue like, look, there's no way we could have known that he would have gone out and commit these types of crimes.
Well, I mean, that's going to be, I mean, that's kind of, I would say that's a little difficult, to say that. And I know Chloe brings up a great point. She says she'd like to hear your talk about foreseeability, address the haters saying there's zero chance the jury could find what happened was foreseeable. If the jury's going to hear both sides of things, if it gets that far, I'm assuming, the state is going to come in and say something or not the state, but the representative of WSU is going to come in and say, hey, this was a guy that was recommended from one of the most pristine or whatever colleges. He studied under renowned author and forensic psychologist, Dr. Catherine Ramsland, one of two persons that was ever recommended for the PhD program, had graduated, had passed with honors, et cetera, et cetera. He came from out of town. We had no history of him before. He'd only been in town for a short period of time. He had never fired anybody with WSU. They had never fired anybody that had a grant. And before, and they're going to claim this, before his name was given to them, they had taken action as quickly as possible. And within one semester, he was terminated. I would assume WSU is going to go something around that realm to try to say that they did all they could in the amount of time that they had and investigated everything. How would that be argued against?
Well, the university, my guess, is probably going to argue something like there was a superseding or an intervening cause, and what that means is that you have an act by a defendant, let's say in this case WSU, and then you have ultimately the crimes that were committed. They're going to argue that something along that line came in to cut off their liability, right? So that's why it's called a superseding or an intervening cause. It cuts off liability, assuming that's kind of the theory that is being used, and it seems like that's at least part of what it is. But I think the reason you see so many allegations about various colleagues' experiences with him, and even the system, kind of like the 911 warning system that they had, to sort of notify each other when they needed help, or when they needed an escort to their car.
Yeah.
You have somebody that's blocking your exit from an office or from a classroom, the things like that. So one of the things that I would be asking about in discovery, if it were me, is okay, how much did university administration, like at a higher level, like deans and upper level administration, were these things elevated to them? How much were they involved in these discussions, and maybe even putting these, sort of these protections in place for students and for colleagues of Kohberger? And so I think you see so many allegations in there, to make the argument that it could be foreseeable.
Yeah.
And I to me, this is just maybe like soapbox for a minute, but I kind of think that foreseeability should always be a jury question. It's kind of my opinion, and maybe some of these causes of action survive and others don't. That's a possible outcome. just because you see a 6-count complaint doesn't mean that all of the causes of action are necessarily going to survive, right? That kind of thing could happen. But I think that, if you're the families or any plaintiff for that matter, you need to build as many circumstances on top of each other as you can, to make that nexus that, look, there is this happening could have been foreseeable, and that there were realistically no superseding or intervening causes to cut off liability. And I think there's a component of this too, that where it could result in a settlement. If it survives a motion to dismiss, motion for summary judgment, if WSU, doesn't want this to continue on for a protracted amount of time, maybe it resolves. I mean, very many civil suits do.
Yeah, many do. And and that's one thing that Steph had mentioned. She said if WSU is smart, they would settle. And I agree. I'm for the families here. I hope they get everything they're asking for. And I don't think it has anything to do with a financial thing or anything like that. To me, it's more so if they don't, and WSU, nothing happens to them, it could be your kid next that they look past or don't take serious, or don't do their due diligence in investigating certain complaints to the fullest, and then you're going to be like, man, I wish somebody would have spoken up sooner and maybe perhaps could have avoided something. And so this is, to me, more so than anything else, corrective action towards the university. And I think personally there was a lot there for them to have known. Me personally also, and I was wondering if this is also in there. I thought, and I'll just kind of spell out my little conspiracy here, but you had the chief of WSU now, used to be the chief of police at Pullman. He was the same guy that interviewed Bryan Kohberger. We knew that because there was an email chain that went back and forth. And he was also in touch with the chief of police of Moscow, Chief Fry, and he was their connect. And he was also talking with the leaders, which they call them the senior leaders, which aren't students. These are just senior leaders, like the dean and others part of WSU. He was in communication with them about what was going on at Moscow. At the same time, in my opinion, I believe he was also investigating Bryan Kohberger. Bryan Kohberger being, I think it was one of the other faculty members mentioned that he was the only person who had been terminated and had funding and a job and housing and all this other stuff. And that's the only person that's happened to. And so I'm assuming that's a pretty big decision that the senior leads of the school would have to make that decision. And we also find out during an interview with the chief there, Jenkins, that the only thing he said he knew about Bryan Kohberger, as far as complaints, if he had any complaints or anything, was that some of the harassment stuff, that he was blocking people in and things of that nature. And so to me, that's not something that gets to the chief of police, unless the chief of police is like investigating the guy for a background check for a position that he applied for, and talking to the senior leads and getting information about that guy's background. He finds out that kind of information. And then we find out that, lo and behold, December 19th, the day that the Moscow chief of police gets the information that the guy they're looking for is Bryan Kohberger, they decide to send Bryan Kohberger a letter to notify him that he's terminated. I don't think that's all a coincidence, but can they prove something there that maybe perhaps, they could have arrested Bryan Kohberger faster if they would have cooperated fully, or if they would have, spoken up about their troublesome student that they had, and maybe perhaps they wouldn't have lost as much evidence. There wouldn't be as much conspiracy. There wouldn't be, this pain and hurt that the victim family members are going through because a lot of information, a lot of evidence has been lost because they allowed this guy to go free for 7 weeks. Is there anything there that can happen for that?
Right. Well, we've heard a lot about stalking throughout the criminal case, and many times when Bill Thompson has said that there was no evidence that that Kohberger was stalking either the house or the kids. Well, stalking is a legal term of art, and a couple years ago, I looked at the definition of stalking in the Idaho. I wanted to know what it was under the Idaho criminal code. I haven't looked at it in the Washington statutes, but it has a very specific definition, and so we're not so much talking about could he have been arrested for for a crime at that point necessarily. I just wonder if one of the things that's going to come out in discovery is, are we going to find out, how does WSU handle referrals to either campus police or even out? When does it rise to the level of maybe they get Pullman police involved? Is there a policy, something in there that WSU wasn't doing? But and I guarantee you, because the complaint references stalking, so much and these kinds of behaviors, that I would think it has to be a part of discovery, and it will be a part of discovery. I don't know if there's any if it was all happening at the same time. I don't know if there's anything to that. I don't want to speculate there, but it's certainly an interesting question to think about.
Now, you mentioned that there's a lot of mentioning of stalking. Is that because it is in Washington? Idaho, the way the law reads, that the person has to be aware, and not only that they, not necessarily they have to be aware, they have to be afraid, annoyed, or feel in fear. And all of those are an indication of being aware. And so if Bryan Kohberger was following and parking outside or parked outside of their job or any of those type of things, as I think it was Cellbrite had found that they had the Mad Greek on his had populated on his phone for venues, and that's where Maddie and Xana had worked at, because the way Idaho reads, is Washington different? Does Washington allow for verbiage like stalking?
Yeah, I don't know what the elements of stalking are in Washington, not having looked at the statute there. But the way I always think about it is there's the, if somebody's charged with the crime of stalking, then the state has to prove each and every element of the crime. But sometimes I think in society we use stalking like more colloquially, right? Like somebody might get a call, somebody might say, "Oh, this person has called me 27 times today. They're stalking me," right? While it might not fall under, a criminal statute of stalking, that's sort of kind of how we refer to it, as a society and in a lot of ways. And so I think that, a lot of this behavior, that I see referenced, in the complaint, may fall, more into that category. But I don't know, because he was never charged with stalking in Washington State, whether it would have fit that definition or not.
Yeah. Yeah, well, we'll see. Kel says timing records would have shown stalking, in my opinion. Well, that's if they would have got to him. The problem with Bryan Kohberger is that the advanced timing records were only saved 7 days. He only had 7 days. And since his phone was off during the time of the murders, his phone wasn't part of the group of phones that they pulled during that night to get the advanced timing records. And since they didn't capture him for about 7 weeks, and I think it was closer to 6 weeks when they actually pulled his, got a warrant for his phone data and his advanced timing records. That was well after the 7 days that it was saved, and so that's why they don't have it. It's not necessarily that there's evidence showing Bryan Kohberger didn't do anything. It's that his entire history, his phone was factory reset and all that other stuff was happening. There is nothing there. He completely deleted everything. And that's off of his cell phone, off of his work school laptop, which Selbright said that was odd because it would have been when his computer would have been the busiest, during his time at WSU, November. That's around, pretty close to the end of the term, and you have midterms and things of that nature going on. They said they should have seen a lot of activity on his phone and his computer, and it was wiped. It was clean. There was nothing there. And so what that told them was that he had done complete wipes. And so he could have very well been out there. And a lot of people get this confused. They think that when they hear no proof of stalking, that means there's evidence that he never went around there, and that's completely false. That's not true. They just don't have the evidence because he completely destroyed everything. But lack of evidence is evidence, in my opinion.
Yeah, the way I always thought about it is, whenever Thompson would say, there's no evidence of stalking, in my mind, I would always follow that by saying that could be proven, necessarily, because his digital footprint could have been erased enough, where they wouldn't have been able, because everybody was early on, right? And I mean, really all the way up until now, people have looked for that connection. There must have been a connection to the house or, to the victims or something. Well, the reality is we're probably never going to know. I mean, unless he tells us, if there was some connection, we may never know what that is. But I think that because stalking, Thompson might have been thinking about it, as a legal term of art. I mean, he's a prosecutor, right? So he has to, he's got to follow the elements of a crime. So he may have been saying that in that sense, simply because they couldn't actually establish, based on the discovery that they had, much of a connection, if any at all.
Yeah. I mean, there's a lot of evidence to indicate that he was well aware. He admitted to this, first and foremost. He's admitted to this. He's accepted guilt. He's got 4 life sentences plus 10 years on top of it. And so knowing that he did this and that he had his phone off and that he got out of there and he drove around throughout that entire time, drove back and forth to that exact same location, waiting for the light to turn off. No shock that the moment that the DoorDasher leaves, my opinion, whatever they used to indicate, I'm assuming there was a light on for the DoorDasher to know that, hey, this is the location of where you're supposed to drop off the food, because the address was kind of weird. Once that light goes off, or once that DoorDasher leaves, that's when he goes in. He goes in and he gets out of there, drives out of that neighborhood as fast as possible, goes through this back road area and gets out of there and back on I-95 where he turns on his phone. So he did all that without, in the dead of the night, in overcast, and I doubt there was a moon out, and super pitch black dark out there. You don't think he never went back there? He never drove around there. In fact, the next day he goes back out there with the phone off again, and he's out there for multiple hours. And so, his actions that he did are a huge indication that he was most likely well-versed with the neighborhood, well-versed with the route that he took. And, I think he planned ahead. I was able to predict the route that he took because of what law enforcement were doing. And I could tell that they didn't have any evidence of him leaving town until there was the camera from the gas station that showed him on a road coming in the direction that was either going or coming from out of town. And then that's when they decide to leave Moscow and start checking gas station cameras in other cities nearby. And so I was able to predict the route that he took based off of that. And it ended up being true because there was only one route that you could get out of town without going across a city camera. And, these ring cameras, they're not going to capture a license plate. They're not going to give you a lot of detail. Majority of them are only going to catch the profile of the vehicle anyways, because they're passing in front of the house. We got lucky that there was one that caught the front end of that vehicle and saw that he didn't have a front license plate. And so, he must have cased out the place. You don't do that unless you case out the place. You don't just get lucky like that. So in my opinion, he'd been out there several times, and they were able to say, I think it was 20 something times within 100 meters, for over extended period of time as well.
Yeah. So, and when I read the complaint the first time, and even more so the second time, I think, but one of the words that, came to mind was escalation. It looked like his behavior was escalating, over a time period. And so, when I think of the question, it is what ultimately happened, foreseeable, to the point where, there could be liability on the part of the university. The answer in my mind is yes. And I'm sure that we're probably going to see some, probably have it raised when the university files their response, and maybe in some motion practice, attacking that, that question, because, particularly with negligence, that's what we're thinking about is foreseeability. But in my mind, it is, I could see escalating behavior, and I think there's one numbered paragraph that it may not, some other people might kind of pass over it, but it talked about a professor or somebody on the faculty, I think, being afraid that he would sue the university. And
John Snyder.
Yeah. And so I think it is absolutely institutional paralysis. I mean, somebody knew, and it wasn't just one person, I think, who thought that his behavior was a problem. And so what I hope that the U.S. District Court judge will do is let that foreseeability question at least go to a jury, and not kind of just cut the claims off at the knees at the very beginning of the lawsuit, because it's assuming it doesn't just settle early on, I think we're in for a fairly long process, because discovery takes quite a while, and there are probably going to be several motions related to discovery, motions to compel, things like that.
This going to federal court, does that benefit WSU or the victims' family members?
I think there's a perceived bias out there both ways, but I think it's only that. I think it's just a perceived bias. Some people think that federal courts favor defendants. Others think that it benefits plaintiffs. I've talked to other attorneys that I know who practice in federal court. They actually prefer practicing there sometimes, because the federal courts tend to follow the rules more strictly, and it's less of a chance that a case can kind of come off the rails, if you will. But I don't believe that there is a bias, or I don't think that it necessarily benefits one side to the detriment of the other. I've just never believed that personally.
Well, doesn't it like stop the flow of information coming out to the public?
That is one consideration. right, is that you would have a tighter, I mean, with access to the courtrooms and things like that. I mean, we're not gonna see something like the, hearings in the criminal case, where, they're all, going to be live streamed and things like that.
And so to a certain extent, that would benefit WSU. I'm sure they don't want their dirty laundry out there broadcasted to the world.
Right, and that's why I think that, assuming the case just doesn't, get dismissed early on, it would probably be. I agree with the commenter who suggested that perhaps they should settle it early on, because that's a way that you kind of prevent that, kind of that never-ending stream of information and leaks and things like that, that come out through the discovery filings and things like that. And attorneys who have PACER accounts, it's the system that the federal court uses for filings, can, access those pleadings and, potentially see the kinds of information that, that's being requested. And that would sort of clue us into, what we're talking about here. But, it's a lot of reading. It's a 130-page complaint, but I think it's worth it to read, because, when you read it, you can kind of see, okay, the issues are narrowed to these, and this is the kind of information that probably both sides are going to be requesting in discovery. I mean, it certainly doesn't have the breadth of the criminal case, right? But there's still a lot there.
Yeah, no, I definitely think that there is. Let's see. I'm going to answer a few questions from the live chat. If you have a couple of questions for me or Matt, put a couple of stars so that we know you're talking to us and not to each other. DTS, how much discovery, and Matt, how much discovery will they allow them to get? How much discovery is the victim's family member allowed to have? It seems like they have gotten surprised with a bunch of the evidence that has been dropped from law enforcement, and they are at they don't have any special privileges in this case where they get the information or they've had access. It seems like they've gotten it at the same time as everybody else has, including, I wonder, had they been more aware of what the scene was like and things of that nature, if they would have all come to an agreement, or at least some of them come to any agreements of a death penalty case, or a plea bargain alleviating the death penalty aspect of it. I don't know if that would have been the case, but my thoughts beforehand, though, do you think, how much discovery will the families get from law enforcement from the case in this case?
Well, with discovery, you have to, I mean, discovery is obtained through a number of ways. In the civil context, the discovery devices that you see are interrogatories, which are written questions, requests for production of documents, depositions, subpoenas, for inspection of documents, or even physical locations if you need to inspect physical location for some reason. You have to be requesting information that is either relevant or would lead to the discovery of relevant evidence. You can't, judges, especially a federal district court judge, is not going to let anyone go on a, you hear the term fishing expedition. They're just not going to allow that. And I don't know about in the federal district for Eastern or Western District of Washington, but most of the time, if you're going to ask interrogatories, you have a limit on the number of questions that you can ask, and it includes like subparts. So if you have like a B, a C, and a D, you have to count those as well. But I'm sure that with a case like this, they're going to be second and and third sets of interrogatories. But the reality is that these cases are intertwined, right? Because things that happened at the university related to him, his TA position, his criminology program are a part of this lawsuit. So I expect there to be some overlap, and the question of the relevance of a particular document sought or object, that's going to be completely within the discretion of the district court judge.
Gotcha. Steph asks, well, if anybody knows, I don't know if you know, I don't know if they're at will policy, if he could have fired him at will without, I'm not sure. If he was an at will employee, does that make a difference in them firing him or terminating him? Or if there's like special policies that they have to follow, would that make a difference if WSU comes back saying, hey, we're following our policies, it took this step and that step and that step, and it just so happened to take, X amount of time. Could that alleviate any culpability from this lawsuit?
It's hard to say. It's really, and that's why I think the discovery component of this is so critical, because we just don't, I don't know what all of WSU policies are, with respect to its employees, and he was both a student and an employee. I mean, they could have, I think they could have removed him at any point. But certainly they would have had to have followed a policy, I'm sure, because he was a student and a TA. But it's probably almost impossible to say, kind of what difference that might have, that might make.
Gotcha. Kelko asked a question, and I'll ask it in a different way. Is there an accusation that they didn't follow their own protocol or policies?
Yeah. I mean, universities that receive funding are, subject to, to Title IX. That's why you have a Title IX cause of action in there, which has resulted in the case being moved to federal court. But there's also a policy referenced in the, it's WAVR 21, I think. So both times when I read the complaint, because I think that this is key in sort of the negligence aspect of this is one of the things that the university did to breach its duty to these families is by failing to follow policies in its own. And also in the complaint you'll see that the claim that the university had a duty to control Kohberger through the use of things like equipment agreements, residential housing agreements, and so those are policies, policies as well.
Interesting. Now this next one is more, I don't know if how much you can do with this, but it says if he was reprimanded earlier and even kicked out of the program, would he have been spooked enough to not go ahead with the crime? Is that something that maybe perhaps the victim's family members or side of things are going to argue, saying something maybe perhaps had they reprimanded him, had they fired him, maybe he moves away and he doesn't cause this, is hypothetical aspects plausible to bring up in court?
Judges don't frequently want to engage in hypotheticals too much. At least with me, they haven't wanted to over the years. So it's, I think that's too speculative. I mean, I can understand how it might be easy to say that, but I think it's way too hypothetical.
Yeah, I agree. Close says many people have complained about allegations in the complaint against WSU being absolute lies that were proven to be untrue in the criminal case. Can I get a response, man?
Yeah. When when you're an attorney, and there are rules of pleading, right? So when you sign your name to a pleading that you file, you're certifying that based on the best of your information and belief that is an allegation that's supported by by the facts and by existing law. It wouldn't benefit anyone in either of those two law firms to just create a complaint, just making up whatever allegations you think you think sound good. I mean, the law firms, their clients are the families. Their client's not the state. Their client is not law enforcement. They don't owe a duty to the state. They don't owe a duty to law enforcement. They have to take the information that is available to them. And it's not out of the question to perhaps see like an amended complaint happen at some point. That happens when you learn facts later on, and it leads the attorney to say, "Oh, look, I need to clarify that. I need to file an amended complaint." But so early on, and not having access to all discovery from the criminal case and things like that, you have to go with kind of what you have and what your client tells you. So it's a serious ethics violation to just write an allegation that you know to be false.
Yeah. Thank you for clearing that up.
You're welcome.
We have a question. I know we already asked this one earlier, but I want to add on to it. So it says, "Great show. Is there any chance BK could be called for this suit?" I know you mentioned probably not, but could he? Is like, if a side wanted to, could they call him for the suit? And in this scenario, what side do you think, if that could happen, what side would? Who would benefit the most from having Bryan Kohberger testify? And how do you think they would? What do you think they would ask him?
Well, I would think the university is probably not going to want to call him, right?
Right.
I mean, look, with potential post-conviction being sought, and I don't know if he's going to do that. I mean, he waived appeals, but post-conviction is a separate procedure, very limited basis. You have to have a serious constitutional violation there, such as evidence of actual innocence emerges, ineffective assistance of counsel, that type of thing, where there was some defect in the plea, where the plea wasn't made freely and voluntarily. And by the way, that's why Judge Hippler in that colloquy asked him so many questions before taking the plea, to ensure that it was made freely and voluntarily. But I would think, obviously, if you're the plaintiff in a lawsuit like this, that's the side where you would want to call Kohberger, whether it's testifying at a motion hearing or at trial. But if he makes he could theoretically be charged with other crimes, right? Assuming they're within the statute of limitations, and no attorney is going to let him utter even 2 words in a hearing where he has the potential to incriminate himself. Whether it's in a civil case, I mean, he makes an incriminating statement that can be used against him. He makes it under oath on the record at a hearing, then that's even worse. So there's no way anyone's going to allow him to testify.
Interesting. Yeah. I thought it would be a long shot also, but you make up some excellent points there about he'd have to get an attorney to clear that. Would that be Ann Taylor still?
Probably not. She's not a civil attorney, but I think that they're gonna. I think that his defense team is gonna remain involved, just because we have the documents continue to be redacted and unsealed. So I think the Bill Thompson's office and the public defender department is going to remain involved. And there's obviously going to be some interrelatedness because of discovery, and maybe they request documents from from the criminal investigation, right? Mm-hmm. But can't imagine Ann would ever say to him, yeah, you know what, it's going to be cool for you to testify in this motion hearing.
Yeah, I find it difficult as well that would happen. Steph asks, I have a feeling that they're going to argue that if they would have fired him, he could have done it anyway prior to parting for PA. And I'll add to it, I would assume that WSU is going to say, hey, he purchased the knife before he even, moved to Washington. Who's to say that they fired him, that he wasn't going to, do this anyways, before he leaves to PA? Is that a argument that you think they're going to make?
Maybe. I mean, I think if they make it, then they're trying to argue the foreseeability, aspect of it. But I don't think that would necessarily be a good argument for them to make on the university side.
Gotcha. Good deal. And so prediction time before we call it a show, since we're getting kind of a little bit over an hour. What is your predictions on this? Do you think it's going to get settled? Do you think it's something that's going to get settled fairly quickly? Do you think this is something that's going to drag? Do you think it'll ever actually get to trial?
Well, you're asking an attorney to do the things that attorneys never like to do, right? I mean, I will say this. I think that if the university is not successful in getting this complaint dismissed, either one of the counts or all of the counts, whatever the case might be, then I think you see the chances of a settlement increase. By what percentage, I don't know. But I just know that at that point, both sides then know that you're going into the discovery period, right? And that can take a long time, because in the civil world, we say discovery is often the worst part of a case, and I typically find that to be true. I mean, we saw it. How many motions to compel were there in the criminal case? I mean, that was a criminal case, but you might be dealing with some of the same sets of documents, right? Or the same material from those files. So, there could be, and another case where we saw this kind of tie-in of a criminal case and a civil case, the Karen Reed case. We saw it there. And, there had to be hearings where you had both the attorneys from the criminal side and the civil side at these hearings, because they're talking about exhibits that were used in the criminal case. And, I don't think it's out of the question that we see something like that here. But I guess all I'll be willing to say is that if the judge allows the lawsuit to proceed, none of the counts dismissed, I think we see the chances of a settlement increase, because I just don't think that if you're the university, you want this kind of thing, to go forward for a long period of time, with more and more information coming out that could be damaging to the university, and that could even lead to the complaint being amended down the line, because you find something in discovery, and maybe you learn that you have another cause of action. You just don't want, if you're a defendant, you do not want those kinds of things happening, right? But whatever ends up happening, I'll just say this, that I hope the families find a resolution that equals whatever amount of justice and closure that they can get. As I said at the beginning, lawsuits are often about both damages and the court ordering a party to do or not do something. And I, on a personal level, I hope that these families get both. We just, and we're doing it wrong if we say that the families are just doing this because of greed, or they're motivated by money, or the lawsuit is frivolous. Those are three things that I just always hate to see. The district court judge is the one who decides whether the lawsuit is going to see the jury, and we can't get into the minds of the family and understand their unimaginable pain, and we have to leave it there. We just have to let this process play out and see what happens.
Yes, sir. Yes, sir. I agree with you 100% there. 100%. Well, Matt, I want to thank you so much for joining me. As this progresses and we get more information out, I would love to have you back on if you would join me again. You know, if anybody wants to hire your services, how can they find you?
I guess just go on the State Bar of New Mexico website and type in my last name, and you'll find me there.
There you go, guys. If anybody in New Mexico is looking for an attorney, you got Matt Rowland here. Thank you again, Matt, for being with us. It was an excellent show. I appreciate your insight. Thank you so much for being here. Guys, hit the like button, hit the subscribe button. I'm going to be back on in about 7 minutes, guys. We're going to be talking about the Nancy Gerthy abduction. You don't want to miss it. So like, comment, subscribe, and we'll be back here in a few. Thank you, everybody, for tuning in. We'll see you next time. Peace out, everyone.